Good evening, everybody. I hope you're all doing well. It is March 4th, 2026. It has been an interesting few days, to say the least, but I hope where you are all safe and that the weather is cooperating, and that you are having a good week. I hope you have some good questions for me tonight, and I'll be happy to try to answer those. Before I get to the questions, I just wanted to go over with you folks, something I was actually working on, just kind of I guess, an instruction sheet I give to my clients, talking about the questions they're likely to get at hearings and so forth. And one of the issues that I started thinking about, because it has popped up recently, is a situation where a judge might ask you to amend the onset date. And if you don't know what I mean by that, the onset date is the start date when you became disabled. So when you file an application for disability benefits, you have to allege something called your onset date. And usually that is the day or the day after you stop working, or the day that your medical condition got so severe that you would not be able to function reliably in a work setting. That is your onset date. But sometimes you'll have a situation where a judge might ask you to change that onset date. So why would that happen, and what should you do? Well, one situation would be that if the medical evidence was very sparse at the time of your original onset date. Let's give you a hypothetical. Let's say that you alleged you stopped working at some point in 2023. Let's just say March of 2023. But the medical evidence, you started going to the doctor, had an MRI in November of 2024. The judge might say to you, you stopped working in 23, maybe you got laid off as opposed to you had to stop working because of your medical situation. The judge might say, well, based on the medical evidence, it looks like the medical evidence confirms that you had a significant problem as of November of 24. Would you entertain the idea of changing your onset from March of 23 to November of 24? And you don't have to say yes. You could say, no, I think I can prove that my condition was disabling in March of 23. And, if you do that, I've never had a judge hold it against you in the sense of the judge was willing to approve the case with the changed onset date, but because you dared to disagree with his suggestion or her suggestion, they're going to deny you altogether. So that I've never had that happen. That didn't mean it couldn't happen, but I think it's pretty unlikely. So I think one would be a situation where the medical evidence is not really, really strong until that later date. A second, much more common situation would be if you changed age categories. And I'm specifically talking about the grid rules. As you know, the grid rules kick in at age 50 and then again at age 55. So if you're, let's say, 54 years and 2 months at onset, the judge might say, well, I can find that you're limited to light functional capacity as of your 55th birthday, but as of your 54 and 2 months, you're limited to light. That would not disable you, but you would be disabled under the grids. So that's something that you do see a good bit, as judges will say, let's move it to the next age category. Although there is an argument which says that if you are really close to that next age category, they can non-mechanically apply the grid rules. So a person, let's say, who's 54 years and 10 months old, we can ask that they apply the grid at 55, even though they're only 54 and 10 months, because it's functionally the same thing. So judges can do that. A third reason a judge might ask you to change the onset date is that the judge is very, very conservative in terms of how he or she reviews evidence, and essentially feels like his or her back is against the wall. They have to approve you, but they don't want to approve you any earlier than they have to. And also judges are under a lot of pressure from Congress and the Social Security Administration to preserve the trust fund, the disability trust fund. So they may say, we'll approve you, but we'll change the onset date. And again, it's a tough call, because on one hand, it'd be nice to know that the judge is going to go ahead and approve your case. But on the other hand, you hate to give up a lot of past due benefits. This issue arises a lot at the administrative level, where at initial recon, we allege an onset date, let's say of 2023, and the state agency approves the case as of February of 2025. So we have to, to make a decision. Do we appeal that? And, if it's a couple of months we're talking about, maybe $3,000, $4,000, I would probably say don't appeal it. But if you're 10,000, 15, 20, $30,000, you might want to consider appealing it. So that is a decision that you and your attorney would probably want to discuss. My feeling is this is something to discuss prior to your hearing, so you know that it possibly could happen, because again, judges will say that during a hearing, and the time to think about this for the first time is not at your hearing. The time is to think about it before and to talk about it with your attorney. And what I would do in a situation, if my client says, well, if the judge suggests that, I'll go with it, or Jonathan, go ahead and challenge that a little bit and see what we can do. But at the end of the day, if the person says, I'll take it, I may push back a little bit. But at the end of the day, if I know my client's going to go for it, I would say, yes, Your Honor, we can live with the changed onset date. And of course, if the medical evidence is supportive of that, then I would probably do that. So it's a judgment call. It's something that you and your attorney need to really talk about. Make sure you're on the same page. But again, the time to think about it's not at the hearing, because what judges will do is they'll say, literally, counselor, if you would like to talk to your client off the record, I'll step away and you can talk to your client. So now you're in the middle of a hearing, you're assuming the judge has stepped away, and you're having a conversation about should you take the amended onset date, in the presence of the vocational witness or the hearing reporter. It's a little uncomfortable. Or sometimes judges will say, we'll call you back. If it's a phone hearing, we'll call you back in 10 minutes, call your client. But, it's hard to make that decision, at the very, very last second. So again, I'm a believer that you want to really think about that kind of ahead of time, so that you are not forced to make a decision when you are, really in, kind of in a you have to make a decision quickly type of situation. So that is an issue that pops up both at the administrative level as well as at the hearing level. And again, my thought is that, if you are, especially if you're getting close to an age change category, 54 to 55 or 49 to 50, something to really think about. And again, I look at it and we talk about it and say, okay, what would we do? And I had one recently where my client says, absolutely not, won't do it. And the judge says, would you consider change? I said, Your Honor, my client and I talked about it. We feel the evidence is very, very strong that his disability began at whatever date, and the judge backed off and approved the case as of that original date. So, you had that happen. I've had it happen a couple of times. Sometimes judges, if they don't know me, they feel like, well, let me try to push you around a little bit, see if I can squeeze you. And you got to know how to say, no, we're not going to go with that. So that's just something that you learn over time, of when to deal with that, when not to, when to yield and when not to yield. Okay, let's go to some of the questions here. We got Haq Assad, who is, I hope I'm pronouncing, Haq Assad 399. I hope I'm pronouncing your name correctly, or that's the way you want it called. But he says, good evening, good evening. One of my vlogs, I guess you're talking about a live stream or a video, you mentioned an OTR decision. How long was the filing to decision? You requested the ALJ make the decision. Was you able to share the nature of the case? Well, basically, an OTR stands for on the record, on the record. And what it basically means is you're asking the judge to decide a case on the record without having to go to the hearing. And that would be a situation where the evidence is really, really overwhelming. And, an on the record or a pre-hearing brief, in my book, they're kind of the same. I mean, theoretically, and on the record, you're actually asking the judge to make a decision. Pre-hearing brief, you're sort of setting the scene and setting out your argument. But typically in a pre-hearing brief, I always would say, we think this supports a finding of disability. I think if it's a case where the person meets a listing, they're on the heart transplant list. I had one recently where they had a liver transplant. And, under the listing, if you have a liver transplant, by definition, you are disabled for a year after the transplant. And arguably, in the year and a half before that, your condition was not very good. So that would be a situation where I ask for an on the record. Usually don't do it in musculoskeletal cases unless there's like an amputation involved, because it's really hard to meet a musculoskeletal listing. I probably would say I'm probably more likely to frame it as a pre-hearing brief. I suspect a lot. I know that there are services out there that will do briefs for lawyers. A lot of us use these services. There's one called Assure, one called Chronicle, where they basically download all the records and put it into one big searchable PDF, which is a really useful tool. Most people use one of those services, and both of those services offer a brief. I've never used it because I looked at the brief, and in my opinion, the brief is very formulaic. It doesn't really, it's written supposedly by attorneys, but I just find it to be most of those very generic, very non-specific, not particularly impressive in my book. Now, again, others may disagree, but I'm not a big fan of those, kind of $100 briefs. So we'll just call them that because that's typically what they charge for it. So a lot of people use them, and again, I don't think it's a bad thing, but it's to me, it doesn't give you it doesn't demonstrate you're prepared or you're as experienced as I think I would like to show, that I am. So anyway, a lot of those $100 briefs, let's call it, they always include a request for on the record. So I'm guessing that a lot of judges get these very generic kind of briefs and they request an on the record. So I suspect that some judges are probably getting a little jaded by the notion of having people ask for an on the record. I think if you're going to ask for it, you need to be able to explain exactly why. The grid rule applies here. There's a listing, or the evidence is so compelling that there's no reason why you shouldn't. I have a hearing coming up very soon where my client is bedridden. Now, that's a situation where, it's probably appropriate for on the record. Now, there's some other factors in there that, maybe it wouldn't necessarily be, as completely compelling as that, but that's a case where I might do that. It's just a case by case kind of thing. Again, I think that judges, my opinion is, and this is just me, all the judges that you deal with, they're judges, they have egos because they're judges and they know they have a certain amount of control. And when you say to them, this case should be decided on the record, you're kind of saying to the judge, I want to take this out of your hands. Some judges I know would be offended by that. Some judges would just see it as you're doing your job. I don't know some of the judges I'm in front of because, as like most of my colleagues, we're doing cases nationally. So it's not like you have you've seen the same judge 30 times. When you have, you kind of know how they might react to that. So my feeling is I kind of imply it in my on the record or my briefs. I may suggest why they would approve it, but I'm probably less inclined to say, this should be an on the record unless I really have strong evidence that it should be. And sometimes I do. So that's a case by case. It's a personality thing. Some lawyers feel like, the way they phrase things, they're very direct and very almost demanding, very, very much of an advocate, which again, you want to be an advocate. Others, like me, I think I feel like, okay, I want the judge to come to the conclusion that I've come to, but on his or her own, as opposed to me trying to jam it down his throat. Maybe I'm looking at it the wrong way, but that approach has worked for me. So to answer your question, Hakasad, it's very much of a case by case. I'm probably less inclined to use the term on the record than others might be, but I will do it on selected cases, but I do imply it in almost every single brief. And I've had a number of cases where I did not specifically ask for it, and the judge went ahead and approved it without a hearing. In fact, I had one, I've mentioned this before, there's a judge in Atlanta who is, very, very low approval rate, notorious for being very difficult. And he gave me a fully favorable on the record when I didn't ask for it. I just did the brief, but he didn't ask for it, but he gave it to me anyway because I laid it out very clearly. So again, case by case, I probably gave you more information than you wanted there, but I think that, if you feel, and I think the other point I would make is, as the claimant, as the client, if you want your attorney to make an on the record request, I think that's perfectly reasonable to say, please do that. And if my client wants me to do it, and I think it's not unreasonable, I will do that. On the other hand, if I think that It's clearly not a case that should be on the record. There needs to be some testimony. There's a question, for example, about post-onset earnings. There's a question about that the person engaged in substantial gainful activity. There is suggestion of secondary gain or drug-seeking behavior or substance abuse, where there's no way the judge is going to give me an on the record. I would tell my client, let's not do that. I think you're being presumptuous there. So it's just going to be a case by case. So I know I gave you a lot more information than you wanted, but that's the way I kind of look at it. Okay. For the initial, Shiloh says, for the initial application, when applying for SSDI under job details, can you go over this tonight? I hear channels say it's important, don't want to mess it up. Mine is a mental claim alone, but asking you, do you stoop, do you kneel, do you crouch, do you reach overhead, supervise other people, crawl, etc. How many hours I did each one. I did customer service, last worked in 23, haven't worked since. DLI, date last insured 28, permanent total with the VA. Also talks about your conditions cause your employer to make changes. And again, there's some additional thing, but 100% personal and total, permanent and total by the VA. Does that help? Doesn't ask in the application. And what information do they? Okay, you've got a lot of questions. Let me kind of knock these out one at a time. All right. So for permanent total, VA, if you're 100%, that will get you to the front of the line, and I would submit documentation, to the file, either with your application or submit it afterwards as evidence that you are 100% P&T from the VA. That just gets in the record. That would not go on a work history form. Okay, so that's a separate item of evidence that, and I would note on the application, I am 100% VA disabled. Please expedite my claim and attach the documentation. So that's how you deal with that. As far as the work history form, the form is, as written, asks about both physical and mental health kind of things. So if you don't have any physical limitations, and I will tell you, most jobs are, in fact, let me see if I can get the work history form and I'll pull it up. Social Security. There's a couple of them, but I think 3369 is, I think, what you're talking about. Okay, yes, that's the 3369. Okay, let me share this screen here so you can see what we're talking about. And give me 1 second here. Share screen. Okay, so here, let me make it a little bit bigger here. This is the 3369 work history report. And so it asks for information about you. Then it asks for your work history and asks for different jobs, 1, 2, 3, 4, 5, and it's over the last 5 years. Don't include jobs held less than 30 days, include self-employment, things like that. And then it goes through each job title number 1. I was a customer service representative at a retail store. And you talk about your rate of pay, and you describe in detail the tasks you did. Did you complete reports? And again, these are just questions they're going to ask, machines and tools. And then it asks, as Shiloh asks here, it talks about how long did you do these things, standing and walking, sitting, stooping, things like that. Now, if your condition is mostly mental, then, it doesn't really matter so much what you got to say there. I will tell you, most jobs in the economy are what they call light jobs. Light jobs are where you're standing and walking up to 6 hours in a day, lifting 10 pounds frequently, 20 pounds on occasion. That's most jobs. So, if at all you are standing and walking more than 6 hours, put that here. That would benefit you because that would take you out of the light category, and realize one of the things you got to prove is you can't do past work. Same with lifting. If you had to, says here, the heaviest weight. So if you put 20 pounds, you're limiting yourself to light. If you say 50 pounds or other, 35 pounds, occasionally that may take you out of light. Frequently 10 pounds is light, 25 pounds would be more than light. So again, that gives you that physical element there. So again, tell the truth, but be aware that the more weight you lifted in a job, that's it's a more difficult thing for Social Security to show you go back to your prior work because most jobs are light. And if you're describing a job that is, more on the medium side, that eliminates that past job. So that's a good thing. And then talks about exposure. Well, again, a lot of these things are not going to apply if you did, things that were mental there. So I think that, this question would be interaction. And you might talk about, and this questionnaire is really more about physical stuff, but I would put in here that you did interaction. Maybe you put in there, I had increasing difficulty doing that because, I'm diagnosed bipolar and I had to take numerous unscheduled breaks. This is really not the form for that, but there's no reason not to put it in there. I think you're going to have an activity report that's probably more appropriate. This form is really, as you can see, much more about the physical elements. So I wouldn't get too worried about, filling this form out wrong if it doesn't ask many questions about your mental health, because that's not what this form is all about. But I would say if there is a physical nature to what you did, put it in there, especially if you can take it beyond light. Again, 20 pounds frequently, 20 pounds on occasion lifting, standing and walking 6 hours. So if you're customer service and you're on your feet for 8 hours, that is more than light. So I'd put that in there. And again, if you can put in there, that you had to, let's say, for example, completing reports, my job required me to complete reports. However, because of my mental health condition, I had more and more difficulty doing that. And my employer moved me to a position where I did not have to do that. So again, you can kind of put it in there, but realize this is not the form for that. So to fill out this form, it's really going to be mostly about your physical, issues as opposed to, one where it's mental health. And then, there'll be other forms where you'd fill out questions about your mental health and how that limits you work-wise, function reports. So again, this form is more about physical, but you can use it to, again, if your physical job was a little more intense than what a standard light job would be, you can reference that here. And if you can put in here in some of these questions how you struggled with some of these tasks or how you had to change the task because it wasn't so much physical, but it was mental, that's just another place to put that. So, but yeah, specific answer to the form, this form is much more about physical than it is mental. And there's really not a lot of places to put anything mental, if I'm not mistaken. Let me just go through the end of it here. I don't think it's just, again, these are just the multiple jobs you've got, work history. And yeah, so there's really nothing much about mental. So that would be a different form. So I would not get too worried about this form trying to prove that you have a mental health limitation. This is purely about physical. Other forms will talk about mental health, but there are ways to kind of get it in there especially if you had to change what you did or you had problems doing it. No reason not to put it in there, but generally speaking, they want to know what your physical limitations were. This is going to be used at a hearing or by Social Security to determine what the exertional capacity of your past work was. Was it sedentary, which is standing and walking to more than 2 hours, light, standing and walking 6 hours, lifting up to 20 pounds, medium, lifting up to 50 pounds occasionally, 25 pounds frequently. And by the way, when we talk about lifting, even if you did it once a month, if it's part of your job requirement, let's say you have to do inventory once a month, and during that inventory, you might have to lift 35 or 40 pounds. In my view, it says occasionally, the most you had to lift is what it asked, 50 pounds or whatever it would be. So even if you do it once every quarter, if that's part of the job requirements, then put it on there because, I think the one thing you can use this form to do, even if you're not a back case or a knee case or things like that, is to get you out of that light functional capacity because that will help you down the road if you do end up at a hearing. But otherwise, this is not the form to really talk about that stuff. Okay. Bala 2001, good evening from New York. I hope, I know that it's been a little chilly up there. I hope that you are doing well. Kathy Clayton says, good evening, Kathy Clayton. Christina, one of my regulars, good evening from California. How are you doing? Christina says, please share the live stream. Yes, please do that. Kathy says, what does it mean when the DDS, which is Disability Determination Services, says your information has been sent to medical review? Okay, so DDS are the adjudicators. These are the people that are like claims adjusters evaluating your claim. And they gather medical information either by using the health information technology, requesting it directly from the sources, or however they get it. Normally they're requesting it from the sources, or they're using the health information technology. They gather that information, then they send it to a medical specialist, who works with Social Security. The medical specialist reviews it and makes a determination as to whether or not that person feels that you are disabled, either functionally or by meaning a listing. Now, there are some relatively new rules that say that in very limited situations, an experienced adjudicator doesn't have to go to the medical specialist, but that's pretty rare these days. So they're going to do that. So that just means that the adjudicator has collected all the information they're going to collect at this point. They're sending it to the medical specialist for review and waiting for that medical specialist to come back with a decision. Now, realize when I'm trying cases, that case has been reviewed by two different medical specialists, and in both cases, the medical specialist said person's not disabled. My case that I was telling you about with a client who's bedridden, medical specialist comment, not enough evidence. Not enough evidence. There's medical evidence all over the file that this person is limited to a bariatric bed. Not enough evidence. They turned it down. So don't get upset or freaked out because the medical specialist turns it down. That's just what they do, and it's not personal. So you can't give up, or you can't get mad and say, screw this whole thing. You have to just keep pushing. Keep pushing. Focused Lady says, good evening. Good evening. Bill Junk says, hi. Hello, Bill Junk. Zippy says, hello, everyone. Hello, Zippy. Mary Simmons. Okay, if I'm seeing a chiropractor in addition to a physical therapist, would seeing the chiropractor cause me to lose my case? It won't cause you to lose your case, but it will not help your case. Social Security sees chiropractic as what they call alternative medicine. And that means that it's not given any weight in terms of a decision. So a chiropractor's conclusions that you are limited to a light or a sedentary functional capacity, that your lifting is limited to 10 pounds, that you need to take unscheduled breaks, it's functional capacity form, that will not be given any weight at all. Now, sometimes chiropractors will take x-rays or other tests, and if they're objective tests, Social Security would consider that. If you go to a chiropractor, it's referenced in that it's relevant in that it shows you are seeking treatment, but it is not, it's not treatment that's going to, the conclusion of the chiropractor is not going to really help you. So I think if you're going to the physical therapist, that's going to mean more. Going to a chiropractor is not going to hurt your case unless you go, instead of going to a medical doctor, physical therapist, nurse practitioner, somebody whose records will be given weight. So let's say if I have a back pain case, it's 100% chiropractic treatment, that's going to be a real problem. It's not going to be a case that's likely to get approved. So you really need to see medical doctors or approved medical sources. Again, a physical therapist would be a nurse practitioner, a medical doctor, things like that. So, but seeing a chiropractor in addition, not a problem, I don't think. Okay, thank you, Christina. So what Christina says, if my live stream or my videos have helped you, please subscribe. I'll also give you a link here. If you want to post a review, you can do that there as well. And that always helps because they do, Google and all the search engines do give a lot of weight. Now the AI tools give weight to these reviews. So yes. Okay. 83, the Casanova. Okay. I've never had this question before, but it's an interesting question. Is it a good idea to plead the fifth at a hearing? The Fifth Amendment, as you may know, is you're not compelled to make a statement that, can or will be used against you. And generally it's brought up in a criminal context. So if, you're asked a question that could potentially subject you to criminal liability, you're not required to answer it. You can say, I plead the fifth. In a civil matter, which is what Social Security is, um, I guess the question would be, if the judge says, do you use street drugs? Let's say cocaine or even marijuana. I mean, it's illegal. Should you plead the fifth? Um, I've never heard of anybody doing that. I mean, my experience is Social Security judges, even though they're federal administrative law judges, they're not going to refer you to a to a U.S. attorney for prosecution. There's got to be more evidence. They're not looking for that. Now, what happens if theoretically it's a mental health case and you admit to murder? Or the judge says, have you committed any crimes? Which I don't think the judge would do. And, saying, "Yeah, I committed a murder," or, going into detail about that, would potentially put you at risk. Yeah, that's probably when I would plead the fifth. I would probably talk to your attorney about that before just doing it at a hearing. Because I think that, a lot of times it's not a big deal. Like, again, using marijuana, drinking, underage drinking, or whatever it may be, even possessing a firearm. These are the sort of things that, they may be relevant in your case, but I've not heard of any Social Security judges referring it for prosecution. But I think if it's something that theoretically could, lead to a criminal prosecution, it's certainly possible to plead the fifth. I've never had anybody do it, but yeah, I think, you could. Obviously, if you do, what you're really saying is, I'm pleading the fifth because I don't want to answer that question. I probably did that thing. And it may bring more attention to it than if you just said, yeah, I used meth or something, but I'm clean now. So yeah, I think that's just something you want to talk to your attorney about, but I've never had anybody do it. All right, Sarah D. Have a long, detailed denial letter from the judge that outlines what's needed for approval. Will my attorney help me appeal since I think I now have the medical evidence post-hearing? Well, the decisions the judges issue are lengthy. They're a template. It's not unique to you. It's a template, and it may spell out what was missing. You don't normally see a judge say, this is what I need. Maybe the judge would say, there is no MRI evidence of disc involvement, and, which essentially means you need an MRI showing disc involvement. The next step is to go to the appeals council. And, there are people who do appeals council work. You could theoretically submit new evidence there, but it has to be remanded back to the judge. So you have to find a reversible error. And for example, if there was evidence, and this is a little more difficult now with the 5-day rule they have with evidence, but let's say there was an MRI from 3 years ago that clearly showed severe herniated disc with nerve root compression. But that for some reason did not get into your file. And now you've got it. You file an appeal saying there was evidence here that was not obtainable, but we've obtained it. Here it is. They may send it back. Or if the judge said in a decision, the absence of evidence is why I'm denying this case. And now you say, we found this evidence. And you got to get past the question of why it wasn't submitted and all that. But let's leave that aside. It would be remanded back to the judge for another hearing. So I think if you have that evidence, talk to your attorney or an attorney who specializes in appeals. And beyond the hearing stage, the next level is the appeals council. Beyond that is federal district court. And both the appeals council and federal district court are different animals in the hearing work. So my feeling is you want to find somebody who does that as opposed to somebody who dabbles in it. I always, almost just about every time, I will bring on another attorney to assist with that co-counsel with me, because I don't do it a lot. Most of my cases, fortunately, are approved. The ones that are not, I'm not really, I don't have a trained eye to see the mistakes. So I'll bring in Carl Osterhout, I'll bring in Brian Konoski, and they will, we'll talk about what the issues would be, and they'll, give me some ideas for the brief, and I'll write the brief or using some of their guidance, and, get that case remanded back. Or if it goes to federal court, they may handle the federal court part of it. So, it's just, you got to find someone who does appeals work, because it is very, very different. So I would say, if you've got your decision, you're within the 60-day appeal period, and the decision indicates what you would have needed in so many words, talk to an appeals attorney and see what you can do about getting that in and getting your case remanded back to the judge. If someone gets cut off from SSDI at 56 years old, which is unusual, and contacted them with a certified letter documentation, what are the next steps with the new disability diagnosis? I would think I don't know, honestly. I think you'd have to reapply unless you're within the appeal period. Because realize, and this question does pop up, if you are subject to a continuing disability review and your original diagnosis, let's say musculoskeletal, cervical, pain or lumbar pain, and that is now resolved following a surgery, but now you have a heart problem that is disabling, that is relevant to the CDR, even though the original disability was based on something else. The fact that you now have a heart problem disability is relevant there. So I think that, if you're within the appeal period, go ahead and appeal that. Otherwise, if you had to file a new application, and this is something where it gets into the date last insured could be an issue. There could be a lot of issues. You're always better off, in my view, appealing a denial and keeping the same case active as opposed to refiling a case. And again, this is something where, you want to talk to your attorney about how and when to do that. Cynthia, one of my clients, how are you doing? Cynthia Chan Tet. Thank you. My pleasure, Chan Tet. Thank you for tuning in. Meow Meow, I'm assuming a cat lover, received my award letter. Congratulations, I haven't heard about SSI. Is it usual to not to hear from SSI first? When should you expect to hear about SSI? SSI is a means-tested program, meaning they look at your household income and your assets. And for example, household income, if you have a spouse or someone else in the house who's working, some of that income may be, they call it deemed, D-W-E-M-E-D, deemed to you as if, for example, let's say your spouse is working, they're going to say, we're going to assume that your spouse's income is money that you can use, so some of that income will be deemed to you and reduce your SSI. SSI is way outdated. So the rules of what would cause a reduction are, have not been updated in years, very low. I think you can have up to $2,000 of assets. So if you have $3,000 in the bank, that may offset your SSI. Normally, if you have both SSDI and SSDI is only concerned about, are you disabled and is there any work post-onset? Assuming that's not the case, they'll go ahead and approve it. If your SSI covered a period, realize, and I don't want to make this overly complicated, you can go back 1 year in an SSDI case, but SSI is only date of application. So if you were found disabled for SSDI a year prior to your application, that's almost certainly going to offset your SSI. Won't be any SSI, but they have to go through the exercise anyway. So they've processed the SSDI. It's easier. They have to do an income and resource interview in SSI. They will do that. Many times it's 100% offset, and you're not seeing the SSI, or you get SSI for at most the 5-month waiting period, then SSDI begins to offset it. But it is typical for SSI to take longer because they got to do more manual stuff, if that answers the question. Dolphin says, hello from California. Hello, Dolphin. Slick Vic is a truck driver and became an above-the-knee amputee in 2025. How likely to be approved for disability? I think pretty good. I mean, if I'm not mistaken, the listing, and let's look at meet a listing, and let's share the screen. We can look at this together here. All right, so here is the listing. We'll go to listings, and we'll go to musculoskeletal listings, and if you see, the listing is difficult to win, but it says here, amputation due to any cause of both upper extremities, including the shoulder, upper extremity, amputation of one lower extremity at or above the ankle, or amputation of one or both lower extremities at or above the ankle with complications of the residual limbs, inability to use a prosthesis. So if that describes you above, I think above the ankle, so maybe I think AKA, I'm not sure if you mean above the knee or above the ankle, but either way, I think that you should look at this listing 1.20 to see whether or not you meet the listing or you equal it. And by equal it, I mean, you may have an amputation at a higher level. Well, actually, this talks about at or above the ankle, so that's pretty low. So anything, above the foot is going to qualify you. But the other part of this talks about inability to use a prosthesis, you know, and documented medical need for a walker. So let's say you don't have a a prescription for a walker, but you got one at the drugstore. You could argue that you meet or equal the listing. Or you could argue again, if you're old enough, that you meet the grid rule because you can't do light work if you're over, let's say if you're over 55 or over 50, you can't do light work if if you can't walk. If you have to be able to walk even sedentary for 2 hours. And if you can't wear a prosthesis or you need an assistive device, you may not meet the listing exactly, but you can meet the grid rule. Or if there's a lot of pain, phantom pain, you might have a functional capacity argument. So I think you've got three pretty good arguments. I will tell you, I have had over the years, I think one or two cases where I had an amputee who had basically, after the amputation was disabled for a period of time, but got the prosthetic leg and went back to work. And, that was the easiest closed period argument I've ever had, because basically say a person who's gone through this traumatic experience was out for a year and a half, but now back at work, judges are like, fine, we'll pay that any day, because that's such a rare kind of thing. So, obviously with an amputation, you're not going to be able to drive a truck anymore. So again, no past work. There's probably no transferable skills. I would look closely at the grid rules or the listing. So that looks like if you're over 50, I think your odds are actually quite good. But if you're under 50, it's going to be a little more challenging, but still, I think probably pretty good. All right. 83, the Casanova. I think this is the one who was asking about the Fifth Amendment. You have to disclose a side hustle at the hearing. Yes, because that is relevant, and that could be SGA. And a side hustle could be, volunteering someplace, or and maybe this is going towards your question is, let's say you're a bookmaker, you're running a legal gambling thing, and that's your side hustle, and you're getting paid, cash, but you're over SGA. Yeah, I mean, the problem there is if you just don't disclose it, you are withholding information, and it's found out later on that you're approved for disability, but later on you get arrested for gambling, and it turns out that you were in fact making $5,000 a month in cash. Now you got a Social Security fraud problem on your hands. So yes, you got to disclose it. And Dexter Morgan. Okay, so I think 83, the Casanova, needs to be careful, because Dexter Morgan gives us the exact reason why. How do I report somebody on SSDI who's not reporting $40,000 a year in income? He's earning outside of his monthly check, obviously capable of earning a living without SSDI. You would contact the Office of the Inspector General for Social Security to make that report. Only thing I would tell you is, it's a pretty serious thing. So, being suspicious about something, this is something you heard, somebody told you this is what you think is going on, you got to be pretty certain, because you're messing with somebody's life. And look, I completely agree. As a taxpayer, if somebody's defrauding Social Security, they should, they should be, benefits should be terminated. But just, make sure that your facts are right, and that you really know for certain they are doing this, that they're working, or you have, and I don't know how, if you're required to give your name, I don't know if you would be involved in it somehow, I don't know, but you would call the Office of the Inspector General, and I think that's where you'd report the fraud. I'll just leave it at that. Okay, I think we've already answered that one here. Vincent Costanzo, Received approval on Monday after February 17th hearing from an ALJ. Good. Back benefits deposited today, much less than anticipated. Very grateful. She based on full retirement amount. I'm 62. Well, I guess question one is, are you getting early retirement? Because you won't double dip. Early retirement counts against your disability. So you get the difference between early and full. So maybe that's going on. The other thing is, don't forget the 5-month waiting period in an SSDI case. So that could also be an issue too. But, if you have an attorney, ask the attorney and you'll get a notice of award that'll also show what you're getting. Did they change the onset date? Ask your attorney, because the numbers need to add up. I've had people say to me, they messed with me. The numbers are completely wrong. It's pretty rare. The numbers are correct. It's just that maybe, like I said, you're getting early retirement and they offset that, or there was some other reason why your benefits were reduced. But yeah, ask your attorney to look at it with you. Okay, so Slick Vic is 35 years old. McCabe, AKA, I guess I'm above the ankle amputee in 25. What's the likelihood? All right, 35-year-old. Okay, so again, I think you have the listing argument. You don't have the grid rule argument because you're under 50. I think you would have either a listing argument or a functional capacity argument. So the question I would have for you is, did they prescribe a prosthesis? Did you have trouble with it? Are you having pain, phantom pain, things like that? What is going on? What is your level of functioning? Do you have to use crutches? You have to use a walker, a scooter? What is your mobility like? And, the question ultimately would be, a sedentary job for a 35-year-old would be something where you're standing and walking no more than 2 hours. So again, with a prosthetic leg, you could theoretically do that. You're sitting for 6 hours or more, or maybe all 8 hours, presumably with a leg that has been amputated or partially amputated. You could do a sit-down job. But if you have chronic pain, okay, that would reduce your capacity to focus and think. If you're on medications to fight an infection, let's say, because have side effects there. If there's a psychological element to it, where you're having PTSD or you're having depression or anxiety, that could reduce your functional capacity. It's probably going to come down to either A, do you meet a listing, or B, are there enough things here where you would not be reliable at even a simple sit-down type of job? And of course, with the amputation, could you stand and walk or do something on your feet for up to 2 hours a day, presumably with a prosthetic? So usually amputation cases are pretty strong. At 35, it's going to be a little more difficult than if it was 55, but I still think it's probably pretty strong. Okay, one more. Okay, Vincent is the person who had an approval, but had some questions about the amount. May I get copies of my attorney's evidence exhibit presented? Yes, you should be able to get that. Again, most of us use a service like Assure or Chronicle, where you can literally download it. I had somebody ask me for a copy of her file yesterday. I tried to send it a couple of times through Google link. It didn't work, so I used Dropbox. Sent her the Dropbox link. She got it. You could burn it to a CD. That, I think, is not something that it should be a problem for you to get. It's just made sometimes, because the file can be big, it could be the deliverable could be harder. Maybe you could zip it and do it that way. But like I said, I either do it through Google Drive or through Dropbox, and I've been able to get files to people that way. And I've done it a couple of times, not recently, burn a CD. All right, Dimple Bellamy from Ohio. How are you doing there? Mr. P, can reconsideration really take a year in California? Unfortunately, yes, it can. It can. Shiloh, this is the person who had the mental health case, but has some questions about the physical functional form. If you receive severance pay after you stop working, how to notate that so it doesn't look like it was still working? Very, very good question. This comes up at hearings. I would get a copy of any pay stub that shows that this is severance. If there's an agreement, get the severance agreement, get that filed. fill out a Form 795, which is a statement by you that earnings after my last day of work was November 3rd, 2025. Earnings after that were part of a severance package attached as a severance documentation. I've done that many times, takes that issue off the table. But judges will ask that, so I'd get it in early, absolutely. All right, Lisa Kelly says, what if you get a sentence 4 remand? That is a appeals counsel. Sentence 4 is one, and honestly, I'm a little embarrassed to say I don't know exactly what sentence 4 is, but it's a type of remand, and I really haven't looked it up in several years. I don't remember what it is, but it's a type of remand where basically it goes back to the judge for some purpose because of some error in analysis or evidence or whatever, and that just means the judge is going to review it again. But I can look that up. I just don't remember what it is. Honestly, it's been several years since I remember that question came up a few years ago. I just don't remember, but it's a type of remand. Save something, save DS. I'll just call it save. Soved Sown. Thank you for your advice and tips. Okay, you are very welcome. Dimple, have you heard anything about the applications taking longer at the local field office before sending it to the state DDS? I heard Walter mention it, Walter not mention it. Yes. The problem is Social Security has cut staff dramatically, and the staff they have, the squeaky wheel gets the grease. There's been a lot of complaints that these 800 numbers taking too long. So they're taking people that should be working on claims adjudication and they're having them answer telephone calls or process replacement Social Security cards. So there are a lot of cases now in what they call staging is what it's called, where it hasn't been assigned to an adjudicator. It just sits there. I had a case out of Texas, was in staging for a year. Ridiculous. And then finally, what you do after 3 or 4 months is write your congressperson and say, I don't think that they've even assigned my case to an adjudicator. I'm suffering. Would you please help me? So, yeah, that's not surprising. You gave me an attorney. I don't know. Hear from them. Why don't SSI tell you why they're denying you? Okay, Brad. Well, when you get a denial notice, you'll get a form letter from Social Security, which will say they feel like, most of the time, they feel like you can go back to either your past work or other work. Realize Social Security uses something called a 5-step sequential evaluation process. And if you fail any of those steps, you get denied. So step 1 is, are you working? So if you're working, they'll deny you at step 1, saying, we denied you because there's evidence that you're working. Pretty unusual, but that could happen. Step 2 is, do you have a severe impairment? That would be something diagnosed. So if you file a musculoskeletal case and you're 100% of your treatments with a chiropractor, it would be denied as being non-severe because you don't have any diagnosis from an approved medical source. Okay. Step 3 is, do you meet a listing? Well, that's, most people don't. So that's just part of the process. That's not a reason to deny your claim because there's other ways to win. Step 4 is, can you return to past work? If they conclude that you could return to past work, that would be a step 4 denial. They would deny you that basis. And step 5 is, can you do any other work? So if they find at the administrative level that you could do other work, you'd be denied. So typically what I see would be they find that either your impairments are non-severe, there's no real firm diagnosis, or it's a severe impairment, but you go back to your past work, or it's a severe impairment, you could not go back to past work, or maybe you could, but we're not going to get there, but there's other jobs you could do. And that's why they would deny you. So they'll tell you that in the letter. It's a form letter. It's kind of hard to read. And they don't say it in the way I explained it. They'll just say, we've made it, we think that we think that your medical problems cause some of the symptoms you've got, but not all of them. And that we think that there's work you could do. So they're not going to tell you step 1, 2, 3, or 4, or 5, but they're just going to basically say, we think you could work. But that's at the time they issue a denial notice. Cajun USMC applied for SSDI in May of 2023, approved in May of 24. Received back pay, excuse me, soon after. In 25, they changed my onset date from May of 23 to May of 24. I appealed and it delayed the overpayment. Okay. I'm confused. You applied in 23, you were approved in 24, got back pay. But now they changed why would they change the onset date after your approval? That doesn't make any sense to me. So I'm afraid I can't answer your question because that doesn't make any sense to me. Um, I'm sorry. Just, if you got approved, they make the change in the onset at that time. They wouldn't wait a year to do it. So it just doesn't. Maybe I'm misunderstanding your question, but that doesn't make any sense to me. Dimple says, my application's been sitting at the local field office since January 8th at step 2. January 8th is not that long ago. That's a couple of months. Once it gets to 3 or 4 months, contact your Ohio senator. I don't remember who that is, but contact one of your senators and say, it's been 5 months. I need to hear something. This is taking too long. That'll get a congressional inquiry going. That'll speed things up. Okay, so Cajun says, I received notification that take the $22,000 overpayment. You can appeal it. I'm still not sure why you're overpaid, unless they found your disability came to an end and they kept paying you. But you can always appeal an overpayment. So, file a request for reconsideration on the overpayment and, take it to a judge if you have an argument. I would talk to an attorney about that. But yes, you can appeal an overpayment. Or you can ask for a waiver. Oh, that's going to be more difficult. Should I stop seeing a chiropractor? Asked Mary Simmons. I can't say you should or you shouldn't. I think you need to have somebody in addition to the chiropractor. If the chiropractor gives you relief, keep going, because your health and the relief you're getting is an important factor. But you need to have medical evidence in addition to that. Now, I will tell you, most chiropractors, not all, but most of them, are comfortable in dealing with the personal injury world. A lot of people go to chiropractors after a car accident. Many of them have associations with medical doctors that kind of bless their work. So, the chiropractor will see you 3 times a week, and then maybe once a month you see a medical doctor who will say, this is a problem, this is a diagnosis. Chiropractor is helping keep going there. But at least you got the medical part of it. But if you're asking me, are you better off with, an approved medical source? Yes. Would I stop going to the chiropractor if it's helping you? Not necessarily, but you got to make sure you have something else there that's going to be enough to carry the day with your case. Shiloh, do I work with veterans? Can you give me PTSD, info about PTSD clients? Just turned 49, my DLI is 28. Okay. PTSD for veterans, those are difficult cases. And let me explain why. Because you're under 50. Nothing you can do about that, but there's a benefit to being over 50 in the Social Security world. The grid rules, there's kind of a bias in that degree. Secondly, Social Security sees a lot of PTSD in veterans, understandably so. I mean, I've talked to many clients who are veterans who, were in combat duty and they saw, terrible, terrible things, best friends getting killed, roadside bombs blowing up, children being killed. I mean, just terrible, terrible things. And, as an aside, just as a citizen, I appreciate your service because the things that you do as veterans, many of us can't even contemplate. So, I have a great deal of respect for anybody who served our country. Social Security, though, sees a lot of PTSD cases. My experience has been, this is just me, that if you're going to win a mental health or a PTSD, which is an anxiety kind of case, number one, there needs to be evidence of some fairly significant trauma. You were in combat, you saw, somebody being blown up, you saw people being murdered, you were or killed in combat. You were in a combat zone for months at a time, living under constant stress that you were going to be shot at, and you have flashbacks. I think second would be that you're getting ongoing treatment. And the VA, VA is the VA. It'd be better to have treatment from a non-VA provider. But if you got to go to the VA, that you're getting intensive treatment, that you're on prescription meds, which is usually not a problem at the VA. It helps if there have been inpatient hospitalizations. That's an indicia of severity. Things like suicide attempts are also indicia of severity. Again, not that that's something I would ever tell somebody who try to kill yourself. Don't do that, obviously. But my point is that on the musculoskeletal side, social security sees a lot of back injury cases. So you go in with a bulging disc and degenerative disc disease and some low back pain, not going to be enough. You need to have a herniated disc. You need to have nerve impingement. You've got to have you need to be on narcotic pain meds many times, or a surgical candidate. There's just elements of things that would indicate that you are significantly impaired musculoskeletally. The same applies for mental health, because depression, anxiety are very, very common reasons people apply for disability. So you have to have more than just a PTSD diagnosis and a couple of prescriptions. It's got to be just more than that. I know that's not a great way to explain it, but that's what I would tell you. So, and I'm not sure what MST. Let me. What is MST in PTSD context? I just want to make sure I know my terms here. Military sexual trauma, I'm guessing, is what you're talking about. Harassment. Actually, I will tell you, I've had problems with those. I've represented another number of clients, female clients in particular, who were, subject to unwanted sexual advances by superior officers. They reported it and were basically told, keep it quiet. The officer was transferred away, and they were never given any sort of therapy or even acknowledged. It's really unfair. And I'm just going to tell you that for some reason, in my experience, that has not moved the meter with Social Security. Doesn't mean it won't in your case, but for some reason, military vets who have been subject to sexual trauma, unwanted advances, assault, things like that, for whatever reason, judges in the Social Security have not been that receptive to it. Again, I think if you've got good treatment, if you've got medication, if you've had therapy, I think that, and it depends also how long it went on, what actually happened. But it will be an uphill battle. I mean, I think it's better that you're 49 as opposed to 39, but it's going to be an uphill battle. Not impossible, but an uphill battle. And I think you want to document everything as much as you can, as far as the trauma, how long it went on, what happened, so you can really tell your story to the judge. And I wish that they were more open to these kind of problems, because it's a real problem in the military, as you know better than me, and it tends to get swept under the rug. And, I think that for whatever reason, the military doesn't want to confront that this is a real problem, and it is. Let's see here. Okay, so Cajun, I'm not trying to avoid your problem, but I'm not sure why why were you overpaid if you were approved? I don't understand that. Okay, I think we've already talked about that one. This is a tough one. Recently denied at district court. Your date less insured is 2024. Wow. I think and I don't want to tell you wrong, but I think that you can reapply, that the date of decision at the hearing is what controls, I think, meaning that you filed an appeal, but the appeal was to consider the judge's decision. So the final decision is not necessarily the denial of the district court, it's the denial of the judge. So if you allege an onset date after your ALJ decision, you should be okay. But you know what? I think that's right, but I could be 100% wrong on that. I think that's right, but I would talk to an attorney ASAP. And the question to ask, maybe I'll phrase it like this, is I was denied by a judge, went through the appeals council, went through district court, got denied. The denial from district court is after my date last insured. Can I file an application and allege an onset date, after the hearing denial, but, during the time it was pending at the appeals council and district court? I think you can, but I would talk to an attorney about that. And I don't want to give you wrong information. So don't take my hunch as being gospel. I think I would talk to an attorney about that to do a little research on that. That's the question to ask. All right, Cajun. And again, I know you're asking about the overpayment. I just don't understand where the overpayment came from. That's what I'm not sure about. Bradley Miller. Should I get a hold of somebody high up? Because I have so much evidence I can't work from 4 doctors. And Brad, this is one of these situations where, Social Security is inefficient. They deny people who should be approved. Again, my client who's bedbound got denied. The process is you appeal and get it to the next level, and hopefully somebody looks at it and agrees with your conclusion that you have compelling evidence. But I think you have to do it within the confines of the disability adjudication process. So if you're at recon, get it to the recon adjudicator. If you're at the hearing, get it to a hearing adjudicator. Lynn says, any suggestions for applying with lupus, arthritis, visual problems? Well, obviously lupus, autoimmune, arthritis, can be physical. Visual is not exertional. It sounds to me like this is a functional capacity argument. So what I would start by doing is, with each of these conditions, write down the specific limitations that you have, i.e. with lupus. Let's say you are very sensitive to sunlight, which many lupus patients are. Make a note, cannot work outside in the sun. Have lupus flares every 3 weeks that last 2 days. Have severe joint pain because of lupus and arthritis, where I'm limited to lifting 3 to 5 pounds at most. Visually, I cannot see a computer screen, or I cannot see distance. I need to have a special screen to see. So each of these conditions, think about the functional issues that arise that would impact you negatively at a job, or even think about like a job interview. Imagine going to an interview and saying, I'd love this job, but I can't see a computer screen. I'm going to need a special computer screen that's 4 times as large. It's going to cost you $10,000. I could then work with it. Okay. I need a job where I can take an unscheduled break to lie down, every 3 or 4 days for a couple of hours because my lupus flares up. I have severe arthritis, which means I would need help with lifting anything more than a file folder. I'm probably going to miss 3 or 4 days of work a month because I have these unpredictable flares. Would you hire that person? No. So I think you just need to identify very clearly the specific problems that would prevent you from being reliable, and make sure those are included in your application and on your forms. And by the way, when you complete the forms, and I was talking to somebody yesterday, a very, very nice, very intelligent client, and she had shown me her form, and it is, handwritten. There's notes down the columns, the side, on top, underneath. Mistake. I would fill it out online where you can type stuff in if you can possibly do that. If you need to attach extra pages, do it typed. Don't handwrite forms. I'm just telling you because, I'm using AI tools. Social Security is starting to use them. They can read typewritten text. They can read it, but it's not nearly as accurate handwritten text. Don't fill out your forms handwritten. Much better off doing it typed. So type in, form 3373. Go to online, just, get I think most free browser plugins like Adobe Acrobat, you can type into it, and just, do it that way. Do yourself a favor. You'll be much better off doing it that way. Um, One of my clients, how are you doing? Finally warming up. Yes, it is finally warming up in Atlanta. And yes, we are. Actually, I had one of the reasons, by the way, I moved to 8:45 Eastern is I have tennis practice on. I play tennis even at my advanced stage, and I'm respectable. Um, and we have. I'm on a team. I'm the captain of the team, which is a major pain in my what because I got to get everybody to put their availability in. I got to make the teams up. People complain that want more playing time, et cetera, et cetera. But anyway, I'm the captain, so I got to go to the practice. So the practice runs from 6:30 to 7:45, and I want to come home and grab a quick bite, and then join, take a shower, obviously, and then join everybody here. But yeah, it was 65 degrees out there, which is very nice, and we had a very nice practice. So um, now, whether we win coming up in a couple weeks, I don't know. Trying to get records from providers that have moved, practiced in another state, and retired. That's tough. Those are very tough things to do. I think that what I do is I provide the adjudicator with as much information as I can. Last known address, if you know where the new address is, go to the state where the doctor is and look at the medical board, get the address, give all that to the adjudicator and say, do your thing. You've got resources I don't have. Find these records, use the HITS system, the health information technology, write the doctor, give them the addresses and say, because a letter coming from a Social Security adjudicator, it's going to carry more weight than coming from you. So I think that, give them the information they need to kind of run it down for you if you possibly can, is what I would say. But those are problems when doctors have retired. Can medical weed affect your case? Friendless foe. Um, I technically, I believe that marijuana is still considered a Schedule I drug. As a practical matter, I've not had a judge say boo about it in years. Now, if you're using it for medical purposes, you've got a medical marijuana card, you buy tincture, you buy, marijuana for pain relief, for glaucoma, whatever it's for. I don't think that it's going to be a problem with the judge because it's legal in your state. You got the card, you're using it responsibly. Where you run into trouble is if there's evidence you're using it to get high or recreational. But if it's being done in a medical context, Social Security theoretically should say it's a substance abuse. They don't. If it's medically prescribed. That's just the reality of it. And I think that I saw where the president is moving to try to get marijuana reclassified as a Schedule III drug, much less serious. It should never be. A Schedule I's like heroin. I mean, to call marijuana a Schedule I drug is absurd. Okay, will SSA notify me before her if you're approved at the state level? How does the state level approval process work? Now that I've been notified the caseworker has everything she needs, does it take much longer? I look at my Chronicle every single day. We have it set up where if there is an approval, a change in status, we get a text or an email. So honestly, I have Christy in my office and Paola in my office get those, and I think Kayana may get them as well. It's a lot of emails and texts, so I don't normally get those. I get the hearing results, but they'll get the administrative ones. But they tell me. So if we get an administrative approval, they will let me know. And then we actually have a spreadsheet we keep, and I'm looking at that all the time, so I'll see it. But I don't actually get the text because it's just it would be overwhelming with all the stuff I'm doing just on a day-to-day basis. But yes, short answer to your questions, we would typically know before you would, a couple of days. And we'll, of course, let you know when we do. Good night, Millionaire Movement. Good night, Attorney Ginseng. Ginseng, that is isn't that an herbal root or a spice of some type? I think it's something like I used to take ginseng as a supplement. People sometimes will call me ginseng, Gainsberg. So it's actually Ginsberg, not ginseng, but I'll take it as, good night. Maybe ginseng is something that will help you sleep. So maybe you should take some ginseng. I don't know. But how are you doing? Gambling is considered unearned income. It kind of depends. I mean, it is, if you're a professional gambler, it's not. Um, I think that Social Security's position would be, we want to make that determination. I don't think that if you hide it and you don't tell them, let's say you hit the tables and you win $10,000, you do it on a regular basis, you're playing poker, as almost as a hobby, but you're doing it for hours at a time. Could that be SGA? Maybe. So I think they just, if there's money coming in, they kind of want to know about it. They then determine, they could decide if it's SGA, or not. But I don't think you should hide it, is my point. Mark Benson, if you can lift and move heavy objects, again, what is heavy? Got to define your terms. But you have full stenosis in the neck that causes pain when you're doing heavy work or light work. Would that be a limited function qualification? Stenosis is a diagnosis. And so you can have 5 herniated discs but not be disabled. You can have severe stenosis, not be disabled. If you can lift and move 30, 50-pound objects, then you're probably not disabled for Social Security purposes, even though you have a significant severe medical problem. So it's all about function, all about the function, how much you can lift, how much you can carry. If you can do it with pain, but you can do it, you're not disabled. This has got to be to the point where it stops you from doing stuff. Excuse me. The lady in the corner says, no work I can do, and you still got denied. So I assume you're talking about the vocational witness. I would just say this. You may have had a very low paid judge, 20% judge. Definitely look at it for appeal. I've had people say to me, the vocational witness said there was no jobs I could do, but the judge might have asked the vocational witness 3 or 4 questions. One of those questions, the response is no jobs, but the other, maybe 1 or 2, there were jobs. Listen, if you can, get a copy of the audio from the hearing and listen to it. And you might be surprised at what you missed, that maybe the vocational witness said there were jobs in response to one hypothetical. So normally if a judge wants to deny the case, he will ask a hypothetical question that gets an answer that describes jobs. And sometimes people don't hear that, but that's what's really going on. Because again, if the judge asks only one hypothetical question and the vocational witness said no jobs, unless the judge is going to deny it at step 2, there's no severe impairment, which could happen. It seems kind of unlikely that you'd have vocational witness saying no jobs to every hypothetical, and you still get denied. Now, I will tell, like I had a case not too long ago where the judge denied me at step 2. There was no severe impairment, which he was wrong, but that's what he denied it for. The hearing went to the vocational witness, and the judge had no questions for the VE. I asked, because he was going to deny it at step 2, I had a question. If our hypothetical person was off task 15% of the day or likely to miss 1 or more days of work per month, are there any competitive jobs out there? The vocational witness said no. So technically, the only question that was asked the vocational witness was no jobs. But the judge denied it on the grounds that there's no severe impairments. So, that can happen too. So I think that you just need to figure out what the basis of the denial is and look carefully. Was it a step 2 denial? Was it a step 5 denial? And, what were the questions really asked of the VE? Mental health counseling made up dates. Yeah, pardon me. John, I don't know what that means. Okay. Asked about sleep apnea. I had my ALJ hearing. The judge didn't bring it up. He ended the hearing after talking about my neck with the VE. My lawyer asked a question to the VE, and she said no jobs available. And the judge did not bring up the sleep apnea. Does it sound like an approval? I'm more comfortable when the judge asks a question to the VE and gets a no jobs answer. Sleep apnea many times is not considered a severe impairment, because, it may not have a huge impact on your ability to perform work. And this gets very confusing, but non-severe impairments, which many times could include sleep apnea, are relevant because they may cause a slight interference with your ability to work, but not enough to rise to the level of significant, potentially disabling, is maybe the best way to put it. So, you know, the sleep apnea is not really ALJ here, and Judge didn't bring it up. He talked about the neck with the VE. Assuming the judge put some significant limitations in the hypothetical, that's probably a good sign. But again, without knowing what the questions were, I can't tell you. I would just, I'd get a copy of the audio. I'd listen to it carefully, and ask your lawyer what the lawyer thinks. As far as what the judge and the vocational witness talked about. Because again, I've seen judges deny it step 2, non-severe, when the hypothetical gives me no jobs. On the other hand, if there's a hypothetical from the judge that gives no jobs, is more likely you won, because judge can't substitute his experience for that of a vocational witness. Okay, so you're saying, Cajun, that you were given a lump sum and that they said it was an error on their part, administrative error on their part, but now they want the money back, that you've applied for a waiver and apparently got denied. It was not your fault, but they're saying too bad. You could go to a hearing on that, and you could certainly say the error was not my fault. This is causing terrible hardship to me. That's the second part of it. This is causing terrible hardship to me for them to take back this money, and I want it reduced or eliminated. But I think that's what you're going to have to do, is get in front of a judge to do that, unless the waiver goes through. But they're going to say, well, it was administrative error. You're going to say, get that, but it's causing too much hardship to me. You're welcome, Shiloh. Let's see. I think we already answered that one. Christina, thank you very much. Shunlove did a reconsideration. I am the man. Hire him. Okay. Thank you, Golfer Pro. I appreciate that. Deuce Misritar is getting RSDI from a family member who's disabled but are irresponsible with their funds, a situation I get a lawyer for. What is an RSDI? Let's see if Attorney Google could tell me. RSD. I see. I learned things here. RSDI. Retirement Survivor and Disability Insurance. Okay. You're getting, it looks like, a disability payment from a family member who's disabled but are irresponsible with their funds. Why would that impact you? If you're getting benefits on somebody else's earnings record and they're wasting their money, it shouldn't affect what you get. So I don't know what you would need a lawyer for. In other words, their irresponsibility is not going to cost you any money, I don't believe. So let them be irresponsible. Typo, sir. Okay, Millionaire Maker said, he was up here, he said something before. Now I can't remember what it was. Maybe good night. I think he said good night. Maybe he meant to say good evening. Lisa Devadovich, I have a question. My appeals hearing is March 17th. However, could they make a decision beforehand based on medical evidence? Yes, that's called an on the record, or as part of a pre-hearing brief, but you have to ask for it. Your attorney would need to write a brief and spell out the reasons why you should be approved. Yes, I saw that, Deuce, that retired. So again, my question to you would be, if the other person is wasting their money, but it's not affecting you, why would you need to get a lawyer? That's my question. Okay, so we're at step 4. They say that everything they need should take much longer. I looked at stats and they don't should take as long as other states. Every case is sort of individually decided. I mean, you know, y- Oregon may be a better state than Texas or Florida in terms of speed, but any one case might take a lot longer. I don't know. Um, I'm hoping that we're going to get it. We always try to get these cases, and obviously one of my clients, we try to get get them everything they need to make a favorable decision. Um, so hopefully they will. I hope they will. I think just getting the case moving along is a good thing. So that's the goal. That is the goal. Um, I don't get anything. I'm not interested in being responsible. They don't care, and my family wants to be taken care of. They're taking proper care of themselves. Um, I'm not interested in being irresponsible, so they don't care, and I and my family want her to be taken care of. So once they're not taking care of themselves, um, are you maybe talking about a probate situation where you get control of somebody's financial affairs because they are not capable of managing it themselves, almost like a letters of what do they call it? There's a term for it, but basically, um, a conservatorship or something like that. You would need a lawyer for that. The question is, do you want to deal with all the issues that come along with that? You know, if you're a conservator, you're responsible for somebody else's finances. There's going to be reporting you may have to do, and you're going to have a person who's going to be constantly contacting you asking for money. I remember years ago, before I knew any better, I had a client. It was not a. I was before I did Social Security, as a matter of fact. Um, I had a client who was needed a representative payee for Social Security, and I was representing him in maybe a car accident case or something. I can't remember what it was. So I foolishly agreed to be his representative payee, and I got assigned to be, or I got approved for that. Well, he would come to me literally 3 or 4 times a week demanding money. And, as a representative payee, my responsibility was to give him money for necessities. And so I said, well, I'll, find a place to live and I'll pay the apartment complex directly. You know, you need to buy food. We'll get you a, grocery card. Excuse me. Pardon me. But I'm not just going to give you cash because, I suspected he was going out and buying liquor or weed. And he got really angry, shouting, screaming, and this is like an ongoing thing. And finally, after about a few weeks of it, I finally just said, you know what? I'm not doing this anymore. I'm not getting paid for it. I don't need a crazy man coming to my office every 3 days and demanding money and, not respecting my responsibilities to take care of, be a fiduciary for this money. So I basically notified Social Security I was withdrawing as rep payee. They then held up his money until he got another one. So it's a tough job. So my point here is that if you take on the responsibility of being somebody's conservator and dealing with their money, then you're going to be, babysitting them is my point. That's all. Conservatorship. I just think you got to be really careful about that. All right, let's see if we got any more questions here. Note about the grid rules, and here's about the leaving review. Okay. I'm not seeing any more comments here, so I will. We've been going for about an hour and a half, and that's fine. Fewer people than we normally have on this one, so I'll just end it now. I appreciate everybody tuning in. We'll be back next week. The only thing I will tell you is my daughter is pregnant and due to give birth in the next couple of weeks. I'll be a second-time grandpa, which is a great job, by the way. It's actually a lot better than having kids. So if you can have the grandchildren first and leave the kids till later, I would tell you to do that. But anyway, if she should be in a situation where I've got to be watching my granddaughter or we're at the hospital, whatever, I won't be here. But assuming that she's still not delivered. She's still got a couple more weeks to go. I will be here, but just wanted you to be alert to that. I'll post something if, in fact, I will be not here because of that or any other reason. So anyway, hope everybody has a great evening. Stay safe out there, and we will see you all. Yes, and as Christina says, please do not forget to like and share and subscribe. And I've got a bunch of new videos coming out, so keep an eye on the channel for that. I've got some cool stuff coming out. So I will see you guys all next week. Thanks a lot. Bye-bye.